Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. You being bombarded by legal letters from your ex's lawyer or from your ex? Well, this episode is for you. We are going to talk with Lynn, a family lawyer of 35 years experience, to what steps you can take and the 5 important things that you can look at in how to respond, when to respond, why to respond, or if to respond at all. Welcome, Mum.
Hello, Laura. Hello, everyone.
Now, we get a lot of messages from people saying that they feel overwhelmed, which is why we started the course and the podcast in the first place, where, you know, they're getting so many letters or they're just getting bombarded with non-stop legal stuff, whether it's from their lawyers or whether or their ex who doesn't have a lawyer. So we thought it might be a good idea today, Mum, to talk about how we can deal with that. So if you're listening today, Mum's going to talk you through how to deal with deadlines that they might give you in their letters, not in court documents, in legal letters, whether or not you should respond at all, some kind of checklist that you can go through and see whether you even need to respond. Number 3 is a bulk way of responding. We're going to talk you through that. Number 4 is a general way of responding. And also number 5, we're going to talk about truth and evidence in letters and when you need to worry about it and when you don't and how to go about that. So thank you, Mum, for coming along to answer all of these questions.
It gives me a break from legal work.
I wonder, I wonder how many lawyer letters you've read in your millions of years working as a lawyer.
Oh, my goodness.
Could you reckon it would be a fair few?
Since the Jurassic times, yes. I've read many.
When it was on papyrus?
Many lawyers. Watch it. Cheeky.
Now, look, I know, you know, because you're a lawyer, if our listeners both have lawyers or if their ex has a lawyer and they have a lawyer, it's the lawyers that are getting the letters between each other. And, but there are some listeners that don't have a lawyer.
And if you've got a lawyer, your lawyer's got to pass that letter on to you to get instructions. And I've learned, having been through it myself, I've always said, I could send a letter from our firm and just put the words to Bar Black Sheep on it, but just opening a letter or email from a law firm makes some people's heart sink to their boots. Some people that will depress them and some people they'll argue with it.
Well, my question with that is, and just to, you know, let's just pretend I don't have much knowledge at all about it, but a legal letter to someone who is not in the legal profession is a bit of a freak out because it feels like it's a court thing already when you just get a letter. But is there anything in a legal letter from a lawyer, from a law firm or from an ex pretending to making it very serious? Is there any legal implications to a letter? Oh,
yes, because you can expect that letter to end up in court attached to an affidavit. And sometimes your response is critical to what you say to that letter. So I can understand why people get nervous. But let's remember, unless you're actually rushed into court or already in court, these are more negotiation type letters usually. But we do, under the new regime, send a letter of a notice of intention to file, and you need to take that letter seriously. So you need to take a deep breath and just think about what the letter actually says. So usually the first letter will be more of a general history and just saying they act and it should offer some sort of mediation option or something. So just go through and pick out any of those actual doing words, and that should give you the thrust of the letter.
Okay. So you go through, you have a look. It's not a legal document per se, but it can be added to an affidavit later and your response or lack of response. Let's talk about what seems to be maybe a lot of people freak out about is these deadlines that are put in letters by their exes or their exes' lawyers that say, respond by this date or blah, 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 or we expect you to give this information by this date. Could you talk everybody through listening today? How do people deal with that? How does a lawyer deal with that? How should people who don't have lawyers deal with it?
So if I was acting for someone and I got a letter saying that I had to respond to something by 4 o'clock this afternoon or tomorrow afternoon when it's not particularly urgent. I either just ignore it or I write and say, that's too soon. I'll need till next Wednesday to get that information. And that kind of takes the sting out of that letter demanding you do something or demanding you tell them something. That's what I do, unless there's something like time with a child coming up on the weekend, and then their deadline's reasonable, I guess. But then you have to say, why did you write so late? So generally what I like to do is take a breath, slow down, just read it through carefully, and then I talk to my client about it. I don't immediately jolt into responding by email or flashing it off to the client. What do you think? You've got to calm it all down and see whether they've got the right to demand these deadlines, for instance. If the deadline says, respond back by next week, I want all of this disclosure for property settlement, or is a week a decent deadline? It's a bit soon, unless it's a simple question they want an answer to, but disclosure and stuff like that. The answer, I guess, is, Rose, how long it's going to take you to get all these documents together, or is it that you just have to look in your diary and you can answer? So if it feels unreasonable to you, it probably is, and you can write back and say, that's unreasonable for me. I need at least till Thursday.
Is it fair to say that maybe in terms of deadlines and responses to legal letters that it would be expected to be, 9 to 5 business hours, a business expectation of response, unless it's some sort of urgent court application or something like that? But when you do you try and think of it like that? Because I know a lot of our listeners probably are used to backwards and forwards emailing with their ex, at 8 o'clock, 9 o'clock, 10 o'clock at night. And if it's the ex saying, I've got this deadline, I want it by 9 o'clock tomorrow night, is it reasonable to say that maybe they could set some boundaries with their exes if it's not a lawyer to say 9 to 5 is when I answer these emails?
That's fine. I think email and text has shortened the communication line between people. And instead of making it easier for people, what it's done is the person demanding the answers expects the answer immediately. I mean, there's this phrase I've seen in some lawyers' letters, please respond by return email, which is, we used to have return mail, which means you'd get it at the 9 o'clock post in the old days and send it out in the 2 o'clock post. But what does return email, it's like implied you have to do it immediately. So I'm just doing some time management stuff at the moment, and I'm batching the emails. So I'm not following their agendas, their timelines. I'm looking at it. And so you're entitled to ask for a reasonable time to answer your letters.
What happens if you end up in court and a judge says to you, why didn't you respond by the deadline? Will you get in trouble?
Sometimes. So if if it's a really unreasonable deadline, you can explain it to the court. The better thing to do is to respond to the lawyer or to your ex saying, I will respond, but this is too soon. I'm getting it together. And then people can't put one letter before the judge without putting the whole chain of correspondence before the judge. And you can say, look, Your Honour, I said that it was too soon, but I did give it to them 14 days later. That sort of thing.
Okay. All right, let's go on to number 2. So we've done deadlines. What about say they get 7 a day or 2 a day or, it's so many by the end of the week, there's 20 emails. How do you determine whether the listeners should respond at all? Well, are there times when you could just not answer?
This is general advice only, because sometimes there might be some little bombs hiding in there. But by and large, I wouldn't expect a lawyer to be sending that many letters a week, honestly. It could well be your ex trying to bully or demand. Ways to control that are to say, look, I only check my emails once a day. So from you, give them a separate email address to deal with. I'll check that email at 4 o'clock every afternoon, and I'll deal with it whenever. Or you can say, even in a case where it's really ridiculous, like little tiny emails going zing, 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 just say, look, I'll read all your emails every Friday,
Yeah.
unless it's
important.
I've seen
Not in a legal sense, but I do know the charity that one of the charities I work with, they have an auto response because I only checked that email box once a week when I had time to work with the charity. So we had an auto response that went out saying, so an away message basically. This email box is not checked except for on Tuesdays and Thursdays between this time, and I'll get back to you then. So if you've set up an email, if you do have a manipulative, controlling or a high conflict ex that's sending you a bazillion, set up a separate email just for them.
Don't call it anything awful though. You need to say your court case or something.
Court or put whatever it is. And then just put an auto responder that says, this email box is checked once a week, and if it's urgent, please.
Or twice a week. If things are really fluid.
Or twice a week.
If things are really fluid, whilst you say that you're checking it once a week, it might pay you to have a quick look at it. Make sure there's nothing in there that's too important, because a manipulative and controlling person could use that against you.
Now, Mum, what are the things that you should be looking at to make sure that you should respond or shouldn't respond? You were talking about the sections of the Act. So can you talk us through that?
So for kids matters, anything under Section 60cc of the Family Law Act, if they start to allege that the kids are saying this, that or the other, and that's not true, or if they start to say they don't have a good relationship with you, they don't want to see all of that, so you need to respond to those sort of like bad parent allegations pretty well straight away, so that you don't have them controlling the narrative, that they just tell you all the time, this is what's happening, and you don't get a chance to answer back. So sometimes you're just going to have to suck it up and respond. Otherwise, their version of events is the one that's on the table in writing. Yeah. So go through the Act and check.
That's for children. Yeah. What about property? So if it's a property matter and you're getting legal letters or exes from your ex about property, what section of the Act should they be checking?
If you're married, it's Section 79 of the Family Law Act, and there's similar section is for de facto as well. So you might as well just use the 79. So anything that talks about your contributions at the beginning of the relationship, anything that talks about what you did during the marriage, so if they say you didn't work or you did work, or you didn't work much, or you kept your money, you might need to say, no, I didn't, in that. But don't get too down in it, because they'll never change their views probably unless you've got evidence.
Well, and that takes us to number 5, but let's talk about number 5 now. So you're getting bombarded with emails. In there, they're talking about maybe Section 60C or 79, and you're like, oh, I need to respond to that. And you do have the evidence, or you want to share that truth. How do you go about responding to a letter like that?
You say, that's not true.
General advice only.
Advice. That's not true, and here's the proof, and attach it to the responding email. That way, I mean, even if your ex knows this thing very well, it lets them know you know it, and if they ever have to try to produce it in court, your email goes with it. If it's a lawyer that's writing these things and just taking as true whatever their client is telling them, and then in other words, the client, your ex is filling that, is making the bullets, and the lawyer's just firing them without looking at their case. If you send evidence back to show that their client is full of it and not telling the truth, that will make the lawyer more careful in the future, and there'll be a very uncomfortable conversation between the lawyer and the client unless that lawyer is not a good lawyer.
Okay, so sometimes it's a good idea to be like, hey, here's the truth and here's the proof. And maybe it's a little bit of a wake-up call for our listeners if their ex's lawyers aren't aware, if they are manipulative or controlling or high conflict. So it is a wake-up call for their lawyer, which is a good thing.
It kind of divides and conquers because their lawyer then starts asking them the hard questions. Not only about that, but then they're going to wonder if anything else they're telling them that you haven't got evidence for might be a lie. Yeah, so it puts them on notice.
Well, that's good. Okay. So imagine that our listeners have created an email address. They get their letters sent there from the lawyers or the ex personally. They get heaps. They've set up their boundaries. They said, I'm only going to check it Tuesdays and Thursdays at 4:00. Don't expect a response the same day unless it's urgent. But they're still getting heaps of letters. What can they do? Is there a way to bulk respond
there is.
to emails? I think how do lawyers do that?
So lawyers do it. We do it. If there's lots and lots of letters, I'll often write back and say, look, you know what, I'll just answer you on Fridays. I'll collate them all and answer them on Fridays. If your ex is writing to you, suggest he puts it all together in one email and sends it, and let him know you're only looking at it on Friday, and you might write a response on Friday. You may go in and sneak a look leading up, but he knows you're not going to answer, and you'll just send one email in response.
So in the beginning of the letter, do you say something like, in response to your letter dated this date, and this time? Do you put it all in there?
I would do that. You can be a bit more casual, I guess, in response to your 8 letters of the past week, but put a date on yours that you're sending it, And then I just say, and you can say this little phrase in there that a lot of, you can say, if you're confident this is true, what your clients, what you've written isn't true, and my version of events is completely different. Which I'll set out in full at the appropriate time. You can just send that and say, it's not true, and I reserve my rights to respond later on.
And so that takes us to that general response. That's the number 4. So you generally, instead of going it, so they might say, on Monday you did this, Tuesday you did this, Wednesday you did this, and Thursday you did this, blah, 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 and you have to respond to it all, and you can just to say.
You can say this.
It's not true.
It's not true. You can say, look, I've read your emails, or I've read your letters of the past 2 weeks or past week, and it seems to me that your complaints are 1, about this such and such a schooling, or 2, about the money I've spent. Don't get into the detail with them. Just give them general headings. And then you can say, look, in relation to...
Sorry to interrupt this podcast, but we have some valuable information that might just help you out. If you're separated or about to be and ready to get everything finalised and sorted, but you don't know what to do next, or you're looking for a way to do your own divorce and settlement without spending thousands of dollars on lawyers, or you're looking to make property and parenting agreements and finalise your divorce papers with your ex-partner while keeping in control and in the know of each step and stage that needs to be done in the legal process, then you already know what you need to do, and that is to sign up to our DIY Divorce Blueprint. Empower, educate and equip yourself with the legal know-how and tools you need to get divorced and finally settle. Work through this course at your own pace without feeling confused, lost, scared and overwhelmed with the family law legal jargon and processes. We invite you to the DIY Divorce Blueprint, lovingly created by Mum, with over 40 video lessons, PDF, templates, swipe files and letter template guides. We're there for you. Enroll now. Go to www.thedivorcecourse.com.au and find out more. Onto it all, and you can just to say.
You can say this.
It's not true.
It's not true. You can say, look, I've read your emails, or I've read your letters of the past 2 weeks or past week, and it seems to me that your complaints are 1, about this such and such a schooling, or 2, about the money I've spent. Don't get into the detail with them. Just give them general headings. And then you can say, look, in relation to the schooling, I don't know, you're able to get all of the documents yourself. I've asked them to, so sort yourself out with that. Or if it's in relation to money that I've spent, I've given you all the receipts, but here they are again. Just sort of don't go through each little point and exhaust yourself, because you've got to start looking at getting to the end of the case yourself in your way. And you don't want them you don't want to be running around chasing red herrings, that they set up.
No. So you've been doing this for a very long time, no offense, but a long time. When do you see the flurries of email action occur? When can our listeners be prepared and go, all right, I'm going to get a lot of letters in the next week or 2? What stages of the divorce process do they happen?
Well, it depends on who you've got is your ex, okay? So a lot of times my poor clients get things on their birthdays. Yeah, wedding anniversary, Valentine's Day, just to upset them, I think.
How romantic.
Yes, not very nice. But for the record, if I know it's someone's, I won't even send the letter if it's a birthday of the other party coming up, or, you know, we check and we don't do that. Because how's that going to help solve anything, you know?
That's right. Yeah. That's right. So just it says the build up to court, maybe mediation.
Court case, mediation. Yep. You can expect it.
And in those instances, it's a good thing because you're trying to negotiate and maybe get not court to happen because you can sort it out yourselves. So so a flurry then is probably a good thing.
Well, you wish they'd done it before.
That's true. But what is too much?
Oh, that's a hard question. I think that if they start raising issues that have never been mentioned before, you need lots of time to respond to that. And you need to say, this is a new issue, and I'll take time to respond. So I don't know. I don't think people should send more than one email a week between each other, particularly in property. I mean, hardly anything's that urgent. You can expect flare-ups coming up to court cases, or if someone loses in court, you can expect a lot of flow. But see, some people have no emotional control, no self-control. So when they think of something spiteful to send, this is not the lawyers, but they just send it, and there's little zips. So usually if they've been made angry or they're worried about something, it's hard to say.
Okay, so you can expect the flare-ups around emotional things or court events or lead up to. We've talked about deadlines and, you know, writing back and saying, you know what, this deadline doesn't really work for me. I'm not going to get it in time. Can we change the deadline?
No, not can we change.
What about
not can we change? You say.
Not can we change. I'll be doing it by this date.
I will be able to respond, or I'll be able to answer you in, you know, a week or 10 days or so, and make sure you do then.
Okay, now let's flip it the other way with the deadlines. And I know we talk about this in our course because it does help a lot with avoidant if they just don't respond to anything. Adding a deadline yourself if you are self-represented and you're writing a legal letter to a lawyer, can you have the audacity to give them a time limit or a deadline?
Of course you can. Of course you can.
Feels a bit wrong
but
to tell
not
a lawyer that
lawyer
they have to respond to you and you're not.
You're giving your ex the deadline through the lawyer. So, yes, you can. But look, if you're going to do, I use them sparingly. Some lawyers, everything's a blooming deadline, but they haven't got what I call an or else, you know, and you think, okay, so I have to answer by tomorrow at 5, or else what? What are you going to do? So what? And there's hardly ever any consequences. What you're better to do if you're going to set a deadline is to give them a reasonable time. 2 weeks or 3 weeks even is fine. Be concise about what it is you want them to do. Number what you want them to do. Give me copies of this document. And stick to it. So one clue that I use, I don't give a deadline at 5 o'clock on a day or even 4 o'clock on a day. I give a deadline at 2 o'clock on the day and say my or else usually will be filing something in the court or seeking costs against them. And that 2 o'clock deadline means I can do it on that day. And in our course, we talk about having an option, having always knowing what you're going to do if they do or don't respond properly or the way you want. And so that's right. I would, if they're particularly recalcitrant, I would send a copy of the orders. Recalcitrant, if they're
I don't know
if they're particularly stubborn. Then sometimes I even draft the orders and, you know, or draft the application and attach it to it and say, this is the application I'm going to file if you don't get sorted. And it really, I give a time and a date. I don't say within 14 days. I say by 2 p.m. on Thursday, the whatever the day. And you'd be surprised how often your email lights up at 1:45 with the responses coming back, because that's a deadline. And frankly, if you've got someone giving you 2 weeks to answer, or else they're going to do something expensive for you, then that's one you really need to respond to. I think if you're getting bombarded, it's easy to miss the important ones, but have a quick scan through. Make sure as they come through, it's annoying, I know, but make sure you can see that there's nothing too bad in them, and then batch them for the end of the week. But have your red flags.
Okay. And what about being firm. You say, take a deep breath, be firm. So how can our listeners, maybe they have been in manipulative controlling or a high conflict, or they're just losing their mind with an avoidant, or they're amicable, that's great. But how do you be firm in letters when you respond back? How do you do that with your letters?
I think it's more about being clear. So be respectful but clear. And don't be snarky. Don't be, if your client had even bothered to look, he would have known. Or as your client very well knows, don't do that. Just say, I'm referring to your letter, and my response is 1, 2, 3. I try and number them and make them clear points. Or you may have had to say, I've had a number of emails from you. I understand these are the issues and here's my response. And I reserve 1, 2, 3, and I reserve the right to respond more fully at a later date. That sort of puts it all away. So if you don't think of it as being aggressive, just be clear and keep your boundaries and keep your respectfulness, and imagine it being read out loud in court. So,
that's a good test. Yeah. Are you going to be, it's like when you were a kid in high school writing letters to your boyfriend. Would I be embarrassed if my mum read this? So
the teacher
ask yourself
says,
the same question.
Show me
would I be embarrassed?
Show me the note.
Show me the note.
I'll read it to the class.
Yes, so that will happen with a judge
Easily,
possibly.
yeah.
So the same question you need to ask yourself, will I be fine if a judge reads this? Okay, so you've got all of those things, Mum. I think we need to just talk quickly about the domestic violence aspect of being bombarded with. So if it's maybe some of our listeners are getting emails under the about property, but
or
there's
about
like 25
children.
of them a day.
Yeah, they're allowed to email.
Or maybe they're getting text messages, and it is part of the process to untangling things, but maybe they're, where's the line?
It's a very
where's
hard
the line and what should they do?
It's a difficult line to draw. So usually a domestic violence order will say that you're forbidden for communicating except in relation to the children. And so I did have a case once where the person mentioned the children in every email, but they were awful emails. And then he just, and such and such, how was such and such at school today? Or such and such. Yes. It was very difficult to prove that actually went across the line to DV. But what I did do, I took the time to print them all out and count how many per page. And we'd had 1,500 emails. So that's a lot. And the court accepted that was excessive and it was a bombardment. I mean, nearly all people, though, if you've got this happening to you, you've got the power yourself to do those strategies we said. Change it to a court email. That might make them settle down. Block them on other access to other emails. If they know it can be exhibited in court, it might tone them down. A lot of people on our children or those parenting apps, because they can't be deleted and because they can appear in court, I think it tones it down, if not the frequency. And maybe you say, the number of these is really harassment and bordering on domestic violence, and specifically ask them to stop, ask them to limit it to 1 a week, and that there's no reason why someone has to send you 2 lines every time they feel cranky.
Yeah. Yeah, because I guess that, like you've said, sometimes it's a way, because we've had some listeners write in and say, I don't know how to deal with this. Now, obviously, if you are in a domestic violence situation and you feel threatened or you're worried about your safety or your children's safety, of course, go to the police, show them the messages, just go and talk to someone, call 1-800-RESPECT, and know that, you can tolerate a certain amount of behaviour to an extent, but if it goes over that line and you feel like it's going over the line, go and speak to someone and see if you can get some help. And you can get a domestic violence order that says that communication can only be about the children and property. And we've had messages of people that are copping this on the chin every day, and it does actually affect their life. I know one person who won't check their text messages. So their phone dings all day and they don't look at their text messages. So it's, you don't want that to impact on your life. So come up with a way around it.
So sometimes people buy a new phone and that one just becomes the yuck phone, and you can keep it in a drawer, you can turn it off at night. Like, it's different if the children are over there. You might want to keep it on. But that way your other phone, your fun phone, your life phone. At least that's a kind thing to have, and you can get your supportive messages from your friends through that one.
Yes.
So just kind of isolate it.
Now, so say you've got a high conflict relationship and you're not self-representing, you have a lawyer, and the lawyer's getting bombarded with your letters. There's some implications there, some cost implications. We've always talked about this, that it can cost $50 for them to read it, $50 for them to write a response.
$50 to send it to you to look at.
Yeah, what kind of strategies can people put in place if they have their own lawyer, their other lawyer or the ex is bombarding them, and it's costing them money? What are some strategies? How can you work with their lawyers? So there's
two main strategies, and it does depend on how willing your lawyer is to work with you to keep the cost down. It's usually pretty obvious that one person, the other side's trying to run up costs. They do it a lot when they're self-represented as well, and they try to make the person who's got a lawyer pay a huge bill. So talk to your lawyer, and these are the things you can discuss. You can talk to the lawyer about having an automatic response to those emails, saying I'll read them on Fridays, You can talk to the lawyer about whether they'd be prepared to send them straight through to you unopened, and that you would get them if you need their help to respond to something. You can only do that, I think, if you give an indemnity to your lawyer and say, look, I'm instructing you to not read the emails, but just to send them directly to me, and then I will ask you if I need help with any of them, if since most of them aren't particularly relevant, and that the lawyer will worry about that because they might miss something vital. But if you've got a clear understanding of what you need to watch out for, and the lawyer's prepared to give you an indemnity, and I've done that a lot. So batching and having an undertaking that from the client that if they want help, they'll ask you for it. Generally, I wouldn't do that if there was a lawyer on the other side. But if there's an individual just constantly bombarding me, that's what I would do. I mean, it's courteous as lawyers to respond to a lawyer. The other way of doing it, of course, is to have step-in, step-out processes. So by that I mean that the lawyer does all the court work and the documents, and so they're on the record around those times for court, but then they stop acting for you as far as everyone else is concerned. You file your own, if you're in court, a notice of address, or they tell the other side that you're self-acting now if you're not in court. And you then field all of the silly emails for a while using those strategies I've given you. And if you see anything that you think you need help with, then the lawyer's still there in the background to help you. And so I do that a lot as well, just to stop that nastiness. The new practice directions are aimed at stopping that sort of behaviour, but it's a long time between when it happens and when you can ask for costs of that. It's just poor behaviour.
Okay, is that how the practice directions are trying to stop it?
Yes, so the central practice direction is starting to, its aim is to get people through efficiently and at the least cost, so cost effectively, and to settle the disputes between parties. So if they get wind of any of this bad behaviour, which is, let's face it, if we're talking about it here, and I've seen it hundreds and hundreds of times, it's not a brand new thing someone's just invented. It's been happening for years. So they're onto it. If they get wind someone's doing that, they may find that person may find themselves hit with a costs order to pay some of your legal fees, or the lawyer might even. There's been costs orders made against the lawyers who are conducting themselves badly in court. So the family courts, Federal Circuit Court and Family Court of Australia are trying to control the process, stop the cowboys, and make it more fair for everyone, hopefully.
Thank goodness. Okay, so look, we talked about, and I guess when it comes to letters in the old days, and I remember I used to do it for you and I worked for you, and after school I did the post run. I had to write down the name of the file and how much money it cost to spend, and I'd stick the stickers on and go stick it in the letterbox. Yeah. Now everyone can just email. But if you are being bombarded and you're a listener today, whether it's your lawyer or it's you, and whether it's their lawyer or your ex, think about what we've talked about. The deadline, their deadline doesn't have to be your deadline. Right. You can always write and say, it's not reasonable, I'm going to be doing it by this time. Of course, general advice only. If there's some legal or else that's really going to hurt you, make sure that you made the right decision. If you've got any doubt,
get some help. Yep.
Yeah. And, okay, the next step is you can always, number 2, whether you respond at all, have a look at the sections of the Act. So it's 60cc or Section 79 for property.
Section 90
if
for
they're
de facto,
trying to, Section 90 for de facto, you can just Google that or look in AusLit. Is that right, Mum? AusLit, not AusLit. That's the cool version of AusLit. Also, you can do a bulk response, so you only read it once a week or check it, make sure there's nothing too bad in there, and then only respond at the end of the week or at the beginning of the week into response of all of their letters, so you're not completely spending half your day every day responding to legal stuff. You can also do a general response. That was number 4. So just generally respond and say, that's actually not true, and I'll respond when it is required to respond to it. And also, number 5, if you've got the truth, you've got the evidence, and it is touching on any of those points in Section 60cc, Section 79 or Section 90.
90 SM it is. SM.
Okay.
For alteration of property
then
interests in de facto.
You give them the truth, you give them the evidence, and you send them that. And, of course, be firm, take your time, take a breath. And Mum, that last thing that you're always really talking about is don't let them dominate the story. Don't let them steal the narrative. Yes. So if they're always saying, look over here at the...
If their story...
And you've got to go, but what about over here?
If their story is about you being a bad housewife or a bad educator, or it's usually an assaulting thing, and they'll be looking to make evidence. Look, Your Honour, I wrote this letter, therefore it must be true. She never cleans the house, or she doesn't feed them properly, or he doesn't this. You feel the urge to respond, and you probably should in a general way. I'm a good housekeeper, and there's no evidence from anyone to suggest otherwise. Or I'm good with schoolwork. But you also don't want to let them get away with the stuff that you need to make points about. On the other hand, your client has just done this, or, so I've seen women usually being bombarded with emails about tiny little things that the other side reckon they've done. In the meantime, the person who's sending all those emails is getting away with everything but murder, stealing the car from the garage, selling the caravan for a profit, and they just keep you busy defending your character or defending yourself. So often when someone accuses my client of something, I have a good hard look at them because they might be projecting and the other person might have done exactly that. The biggest one is your client's got a separate account. Oh, have you? I ask them, have you got it? So then I start looking a bit deeper because,
Yes. Yeah. And I mean, that is one thing that they talk about with narcissism. It's a projection. Sometimes they, if you're in a relationship and they're accusing you of cheating, you better check that they're not cheating.
Well, also too, because they've thought of it and done it, they assume everyone thinks like them. And often you'll be horrified at some of the suggestions they come up with. Who would even do that? Who would even hide money in the TAB, have a TAB and credit? Who would put money in on a credit card, thousands of dollars, but it's in the positive? But people do offshore. Yeah. It's just amazing. A particular person.
Well, if you're interested in that kind of story, listen to our DIY disclosure because Mum talks you through all the places people hide money. So definitely check out that episode. Mum, I thank you so much for sharing your wisdom in this. I think it was important for us to touch on responding and if you're getting letters and bombardment, what can you do to set up some boundaries to save your sanity and to keep, still doing the right thing legally, but also getting your time back.
I know, it's hard. You've got to balance between, that's why this is general advice, because there might be a real doozy slip through while you're applying one of these strategies. So you need to be vigilant, but I would save your responding for one day a week. And like I said, you can put your phone in another room. You can only check your court emails every couple of days. That will help you. And by the way, I think I've mentioned it before, but when you set up your new email, give it a respectable name because you know what happens when you print out an email. It's across the top. So you don't want sort of sexy 63 or whatever.
James Bond 007 or something.
No, you want it to be polished.
Yes.
Okay.
Yeah. All right. So if you have found this episode informative, we would love it if you could jump on the Apple podcast section and give us a review. We've been loving listening and reading the reviews. We will be choosing another person next month. So we've got 2 more weeks. So get in there and write us a review. And we've been having some great success with our members, and Mum's been having a great time having a chat with them and making sure everyone's going okay. If you're interested in looking at our DIY divorce blueprint, go to thedivorcecourse.com.au, or you can also, we are going to be doing another webinar, and this webinar is going to be on who stays in the house. So we're talking about property settlement and your rights in family law, and Mum's going to be talking you through all of that. That is free. So jump online, www.thedivorcecourse.com.au, and click on reserve my free webinar seat. And we're really excited about those webinars because Mum actually gets to see the people that, not see, we don't see you, but we get to respond to, and we always do a live Q&A at the end and talk to those people that have been listening. So it's a two-way thing instead of this one-way thing where we think no one's listening.
And Laura.
But they are, because we're in the charts all the time.
But who stays in the house is really relevant right from the very beginning when you separate. All the way through to when you're negotiating who's going to keep the house, who could buy the house out, all that. So it's the whole gamut, and maybe in domestic violence as well. Yeah, so that'll be fun.
This is true. So looking forward to that, Mum. Thank you, everybody, for listening, and we'll catch you again next week.
Bye.
Thanks, Mum. If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording,